Hello, everybody, and welcome to Political Bite number 318, dated October 13th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thanks for tuning in. This Political Bite is entitled The Fictitious Article 5 Constitutional Convention. Before I begin, however, I'd like to invite you to subscribe to my YouTube channel, Warresley Shelton, M.A. In addition to that, please also click on the little notification bell immediately to the right of the subscribe button. In doing so, you will receive notices when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thanks so much for tuning in. Again, this video is entitled The Fictitious Article 5 Constitutional Convention. Now, if you're not familiar with constitutional law or have no freaking clue as to what I'm talking about when I say a constitutional convention, I suppose it'd be better if I begin by reading Article 5 of the United States Constitution. It reads as follows. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. So if you're still like, worry not. An Article 5 Constitutional Convention is simply another mechanism of adding amendments to the U.S. Constitution. The framers deliberately added the convention method within Article 5 as an alternative to proposing constitutional amendments in case we ever had a Congress which was too recalcitrant to propose amendments to the document that the people clearly wanted. Okay, and for the record, since 1789, there have been more than 11,000 proposed constitutional amendments. All right. Only 33 of those have ever made it to the states, and only 27 of them have ever made it into the Constitution itself. So the Article 5 Convention is a way of calling a constitutional convention to propose amendments to the document, or, in a revolutionary sense, scrap the thing altogether and start afresh, all right? Congress cannot do this, ladies and gentlemen. I just want to make that emphatically clear. The only way a constitutional convention itself can be called is by way of the states, okay, on the application of the legislatures of 2/3 of the states, all right? That is how a constitutional convention is called in the United States, and this is a power that has never been officially exercised. However, we came very close to one a little over a century ago when the Congress thankfully passed what would become the 17th Amendment to the Constitution, providing for the direct election of U.S. senators. All right. Before that, senators were chosen by the state legislatures. All right. One reason a lot of Americans fear a constitutional convention is that everything, and I mean everything, would literally be on the table. There would be no subject which would be off limits with respect to proposed amendments to alter any aspect of our government or society. And that is why many Americans dread the idea of an Article 5 Constitutional Convention. Okay? Congress itself would not be safe. Neither would the presidency. Neither would the Supreme Court. With an Article 5 Constitutional Convention, anything and everything would be on the table for proposed reform, and thus it would be wise in the minds of many to never, ever, 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 ever let this happen. Okay? So, in times when it may have been very close, the Congress itself has relented and passed the proposed amendments where the people have demanded such. Okay? So now that we have established what an Article 5 constitutional convention would be, once such amendments were passed by the convention, they would still have to be ratified by 3/4 of the states. All right. So again, just because it's proposed doesn't mean it's going to get ratified ultimately. So this particular video is actually one of my writings from back in 2018 in designing a fictitious U.S. constitutional convention. And technically, I'm not wrong about a single drop of it. You know why? Again, we've never had one, and Congress has passed no laws establishing any structure or guidelines for how such a convention would go about, what would be the process from start to finish, aside from, the proposed amendments, which of course, would have to be approved by a certain amount of delegates there, and then of course ratified by the states subsequently. But, with respect to who would preside over it, who would, be selected or elected to serve as delegates to the convention from each of the states, all of that, ladies and gentlemen, would be totally up in the air. Okay, and that's why, for many, it's such a scary thought with respect to having an Article 5 convention, because, who knows what could come out of it. All right. 2/3 of the delegates there approving a particular amendment might reduce the Congress to a unicameral legislative body, abolishing the Senate and leaving only the House of Representatives. All right. Such an amendment might from such a convention, you might get an amendment that would abolish life tenure for federal judges. All right. You might get an amendment which would repeal the 22nd Amendment, allowing an individual to be elected once again to more than 2 terms to the presidency. One can still serve more than 2 terms in the presidency. You just can't be elected to the presidency more than twice. Framers are very specific with that amendment back in 1947. So, we don't know what amendments could possibly come out of an Article 5 constitutional convention. All right. And again, I don't, in my lifetime, at the time of this recording, I'm 36 years old. And if I am allowed to live another 50, even 60 plus more years from where I am now, I don't foresee this ever actually happening, because power never surrenders, all right, anything, without demand, as said by the great Frederick Douglass. And, I, can't foresee, Congress ever allowing an Article 5 convention to happen, all right? The people will demand of Congress to pass these amendments, any amendments that the people may want, lest they petition their state legislatures to call an Article 5 convention, all right, of which, an application of 2/3 of the several states, all right, Congress would have to call such a convention, all right? So let's dive into my fictitious Article 5 constitutional convention. And then at the end of the video, if you make it that far, you can tell me what you think of it accordingly. All right. So come on this journey with me and let's have our fictitious Article 5 constitutional convention. Again, this was written in 2018, so pardon the dates. All right. So with the dawn of the new progressive era in the 2020s, the American people seemed to be rekindling a spirit of social reform not seen in more than a century, of course, dating back to the 1920s. Many of the rights and freedoms gained in the 20th century through court decisions began to suddenly seem unsafe, as few, if any, of them were written into the nation's fundamental law, the Constitution, of course. Additionally, more desires for equality began to be demanded as people were no longer satisfied with advances through litigation. Lastly, a desire to promote structural reform in the U.S. government had finally reached its peak. In many states, the citizenry began to petition Congress to pass constitutional amendments and thus enact their rights into positive law. Positive law, of course, being law that is clearly written down, all right, in black and white. As one would expect, the Congress was deadlocked over many of these issues and was unable to come to a consensus about how to word these proposed amendments. Little, if anything, was accomplished, but the people of the states did not acquiesce. In response, they began to ask their legislatures to petition Congress for an Article 5 constitutional convention. Pursuant to Article 5 of the U.S. Constitution, 2/3, roughly 34 state legislatures can petition the Congress for a constitutional convention. Once the amendment proposals had been enacted, the legislatures of 3/4, or roughly 38 states, would still need to ratify them. Okay? So beginning in 2021, the drive began in no less than 30 states to do just that. Okay? But there were problems with such a proposed convention, believe it or not. So first, no constitutional convention had ever been called before, all right? Thus, there was no precedent, like I mentioned earlier, for how this convention would actually go about. Next, there were no laws regarding how such a convention would function from beginning to end. What would be discussed? Who would lead it? All of that was up in the air. Despite these uncertainties, the people still demanded such a convention and that their state legislatures join the call. New York became the first state in November 2021 to petition for such a convention. They were soon followed by Massachusetts, Maryland, Connecticut, Delaware, and New Jersey, bringing the number to 6. In December, the rest of New England joined the bandwagon, bringing the number to 10. California and Nevada soon petitioned after seeing the eastern states rapidly close ranks. Pennsylvania, West Virginia, and Ohio then sent their petitions in. By March of 2022, the number had reached 27. Only 7 more states were needed until Congress, by law, would have to call this constitutional convention. The states where the matter was debated the heaviest were Tennessee, Virginia, Florida, Arizona, Michigan, and Missouri. Finally, in June, Florida and Alabama sent in their petitions, followed by Alaska, Michigan, and Virginia. 2 states held the balance here, and both were too close to call at first. North Carolina sent in its request in July, and the last holdout, Wisconsin, sent in its request in August, bringing the number to the required 34. The people had spoken, and the Constitutional Convention would soon be underway. In response, Congress worked diligently to pass a law which would govern how the convention was to take place. The bill provided that each state was permitted to send as many delegates as it had in the House of Representatives, in the House of Representatives, of course. Additionally, no more than half of each state's delegation could be members of state government. Members of Congress were not permitted to be part of the convention, and there were no limitations on the subject material to be discussed. The convention would be presided over by an elected chair from one of the state delegations and was to last for no more than 90 days. So the convention only had 3 months, all right? All proposed amendments had to be approved by at least 2/3 of the delegates present. Okay, and the states were given 30 days to select their delegates however they planned on choosing them, either by appointment or election, all right? And the start date was set for October 1st, 2022. Upon completion, the president signed the bill into law immediately, all right? Before the start time, the delegates from all 50 states began to gather in Washington, D.C. to commence one of the greatest events in American history, the Second Constitutional Convention. Upon the arrival of the delegations, they proceeded to select a chairperson from several contenders. The choice was former Harvard law professor Alan Dershowitz of Massachusetts. We all know Dr. Dershowitz, as a seasoned constitutional law expert, who was expected to provide guidance to this unprecedented convention in American constitutional law, all right? He would provide the structure and clarity, all right, that the event desperately would need, instilling a sense of trust, even in the most skeptical individuals. All ideas were open to debate, but respect of all positions was demanded by the chair, who conducted the forum almost in a court-like setting. The first order of business for the convention was to amend Article 5 itself, all right? Almost everyone agreed at the convention that the Constitution at present was too difficult to amend by requiring so many states to consent on proposed changes. A motion was made by the Illinois delegation to reduce the number to 1/3, or 33% of the states. Several objections were made that this was much too low, making the document far too easy to change, which is just as bad as too difficult. An alternative motion was made by the Maryland delegation to increase that number to 2/3, or 66%, all right, roughly 33 to 34 states. This measure was more acceptable to most of the delegates, although some still thought this was too low. After a lengthy 2-day debate, most delegates present approved of the suggested change to Article 5, making the Constitution easier, but not too easy to amend. Dershowitz recorded the proposed amendment accordingly, all right? Thus, the Maryland proposal was accepted, all right, reducing the threshold from 3/4 of the states to 2/3. It's a big difference, all right? Next on the agenda was the structural changes to Articles 1 and 3 of the Constitution. Accordingly, Article 1 was targeted first. The Massachusetts delegation proposed imposing term limits upon the Senate and the House of Representatives. Senators were allowed to serve no more than 2 consecutive terms in office before being ineligible for re-election. All right? Once they left office for at least 1 full Senate term, they would again be eligible for election to that body. For the House of Representatives, the same mechanism would apply. All right? 2 consecutive terms. Then a race had to be sat out before they would be eligible for re-election to the House once more. Connecticut seconded this motion immediately. There was opposition from California, which, while approving of the basis of the Massachusetts plan, wanted to render the individuals totally ineligible for office in Congress after serving 2 terms. All right, more extreme proposal. Immediately, several smaller state delegations rose in support of that. All right. Another idea floated by Texas, all right, wanted both the Senate and the House apportioned on a population basis, but it didn't touch term limits. All right. Now, the smaller states, needless to say, rose up in tremendous opposition to the Texas motion. All right. Because that would, of course, give the large states, super control in both houses. All right. It's in the Senate where each state has equal power. So the small states weren't about to take that without a fight. All right. So after calling the room to order, the chair polled each of the suggestions, and the Massachusetts plan carried the most votes and was certified. All right. So that moved them to Article 3, which, of course, is the federal judiciary. The Mississippi delegation proposed eliminating life tenure for U.S. Supreme Court justices, all right, and giving them non-renewable 20-year terms. Lower federal court judges would retain their life tenure. New York's delegation seconded Mississippi's motion, all right, and the matter was debated. Indiana sought abolition of life tenure for all federal judges and approved of the 20-year term, non-renewable, for the entire federal judiciary, from the Supreme Court down to the district courts. Arizona wanted to allow the Supreme Court to remain untouched, but sought to eliminate life tenure for lower federal court judges. Again, debate ensued, and the poll was called by the chair. It was real close, all right? The Indiana suggestion, all right, was adopted, okay? Thus, seeking to eliminate the life tenure for all federal judges and giving them all a 20-year non-renewable term, all right? I personally wouldn't have voted for that. I would have voted for the proposal for simply eliminating life tenure for the Supreme Court and, allowing the lower federal court judges to stay in place, all right, for life. But the Supreme Court, 20-year non-renewable term actually doesn't sound like a bad idea. Even if the Supreme Court justice is 40 years old, that's 20 years of service. That would make them 60, all right? And then they could serve out the rest of their life tenure on a lower federal court. I was once reading a suggestion around to that extent, and it was actually pretty decent suggestion, That way they still have their life tenure, but they're not sitting on the nation's highest court, for all eternity, all right? So, as it were, all right? But back to the story, all right? So, next, a balanced budget amendment was proposed by Delaware and seconded by Florida, yet strongly opposed by California, all right? A lot of debate came after this, okay? And certainly by states where a lot of federal money was spent, such as Alaska and Louisiana, and Maryland, and Virginia, all right? And after a week, though, the measure would ultimately be rejected because it would be absolutely ridiculous to hamstring the federal government with a balanced budget amendment when the federal government has its financial hands in so many pots in the states, all right? To cripple the federal spending power, especially, now, of course, the pandemic wasn't around when I wrote this, but especially in lieu of pandemic times, imagine if they were crippled on their spending with a balanced budget amendment. Ooh, wouldn't have been too good. That's all I'm going to say with that one. All right. But ultimately, the balanced budget amendment was rejected. All right. So lastly, the Virginia delegation offered a D.C. statehood amendment. All right. That was immediately seconded by Maryland. All right. Although there was a lot of structural disagreement as to what aspects of the old district would remain under federal control. During the debates, it was agreed upon that the federal government would only control the lands immediately surrounding the U.S. Capitol and the White House and the Supreme Court and other government-run installations. The matter, interestingly enough, did pass by a bare majority. All right. Mainly supported by northern states, and southern states really didn't have much of an opinion on it outside of, Virginia and West Virginia, all right? So then the convention moved on past government reform itself and then into the rights amendments. First to be discussed was the right to privacy. The Michigan delegation proposed the Privacy Amendment, which would include freedom from governmental interference in one's personal effects, reproductive freedom, and business affairs without probable cause. This was seconded by Hawaii, all right? and it was hotly debated due to the vagueness of the amendment's wording. An alternative suggestion from New Jersey worded it to include reproductive rights, as well as personal belongings, personal records, information, and background information. All right? Michigan seconded New Jersey's more specific wording, as did Alaska and South Carolina. The measure was subsequently approved by a supermajority of delegates. A new Equal Rights Amendment was submitted by the state of Wisconsin that required all jurisdictions to give men and women full equality under the law in permissible circumstances. All right? And what I mean by permissible circumstances is wherever humanly possible to treat men and women with absolute equality. All right. Of course, certain distinctions had to be made in certain areas, of course. But when and where at all possible, men and women should be given the full equal protection of the laws. All right. Men should not be given preference over women. All right. And women should not be treated as subordinates to men. This was approved by all delegations, although concerns were made as to how this would relate to the armed forces. Okay. So despite the issue, a majority approved the matter without serious debate. After 2 months, the convention adjourned with its proposals to be submitted to the states. Now the nation would wait anxiously to see how much of that work would bear fruit or crumble. All right? So that means our proposed constitutional convention began, all right, in 2022, all right, roughly October 1st, 2022, and concluded, all right, 2 months later, in December 1st, 2022, with a lot of interesting proposals to be sent to the states. And so from that, now 38 states, 3/4 of the states would have to approve these measures for any of them to come into effect. Each and every single amendment individually would have to be approved for it to come into effect. And I just want to talk for a minute, about why Americans are seemingly so, hesitant to amend the Constitution when so many problems would be solved if we did. A lot of the debate, in society today is over the role of government in society. And a lot of people, of course, that represents the conservative and the liberal divide. Liberals, of course, believe that there is no area in which the government is forbidden to come into to help out the American people. And the conservatives believe that help or assistance from the government, whether it be the state or federal government, should be limited as much as possible, only when absolutely necessary, that the people themselves, should have the most to say over their own destinies and not being told what to do by the federal government or the state governments. And, our Constitution, our government itself was designed for a small country of 3 million people, all right, that only stretched from the Atlantic seaboard to the mighty Mississippi. We have grown into a nation, the 4th largest nation in the world by total area, and one of the largest in population, though America is certainly large enough to hold an additional 600 million more people. We have a vast nation, and our nation has grown so substantially since the Constitution went into effect on the 21st of June, 1788. With that in mind, okay, Thomas Jefferson once said in 1816 that, with a lot of Americans, like I said, don't want to change the Constitution because they view it as, almost a sacred document. Jefferson said in 1816 that we should not treat the Constitution like the Ark of the Covenant, too sacred to be touched, because it's not the Ark of the Covenant. It is a regular document written by regular guys, written for a regular nation. The framers of our Constitution certainly would look at us today and probably say, you guys are still using that? And even if they might feel a little proud of themselves that we're still using their work from, 233 years later, they would probably say, you guys have only amended it an additional 17 times, all right, since 1791? Wow. Either you guys are incredibly lazy or we were incredibly foresighted. I think the former is more true. Framers were incredibly foresighted people, but Americans are very lazy and simply scared to touch the Constitution, and it should not be that way because Article 5 specifically provides for the amendment process, and we should not be scared to exercise it. So I thank you so much for listening to my video on the fictitious Article 5 Constitutional Convention. If you have any questions or controversies, leave them down below and I'll be happy to answer them. If you've not subscribed to my YouTube channel at this point, please do so now, Juarez Lee Shelton, MA, and click on that little notification bell. Thank you so much for listening. If you made it this far, take care, stay safe out there, and I'll talk to you at the next video. Peace.